Yes.
Passover matters under the heading orders with default serial number 22, EA number 15241 of 21, Mr. Arun Kumar, Photo Commissioner.
Yes. Non appears adjourned for 2 weeks. Non appears in the second column. Adjourned for 2 weeks.
Under the heading fresh filing, serial number 30, EA number 2088 of 22, Mr. Raja Ravi Shekhar Singh.
Non appears in the second column. Adjourned for 2 weeks.
Serial number 31, EA number 2382 of 22, Mr. Mohammad Naseem Akhtar, Ms. Kavita Kumari, Photo Commissioner.
Same order. Non appears on second column.
Serial number under the heading admission fixed cases, serial number 32, EA number 2590 of 22, Mr. Dilesh Kumar, Photo Commissioner.
Yes, Your Lordship, I am appearing on behalf of the petitioner in this case.
Yes. Where's the APP?
Mr. Ashok Singh has appeared on the last date.
Where is
I
Mr.
was given to him, Your Lordship.
Where is Mr. Ashok Singh?
In this case, the petitioner is in custody since February 2020, more than 2 years. Charge has been framed in the month of June 2020. After about 1 year of allegation, Your Lordship, occurrence, the affair has been instituted.
No one appears on behalf of the state. Raise this case on Monday.
Serial number 77, EA number 11171 of 21, Mr. Virat Kumar, Mr. Gautam Kumar, Photo Commissioner.
No one appears on second call, also adjourned for 2 weeks.
Under the heading orders with defect, serial number 1, CMP 516 of 16, Mr. Tapan Kumar Mishra.
Your Lordship, in this, I'm praying for just 1 week time for removing the defects, Your Lordship.
The case of 2016, you have not removed the defects.
Yes, Your Lordship, just 1 week, last indulgence, Your Lordship.
1 week peremptory to remove the defects.
Lordship, obliged, Your Lordship.
Serial number 2, CMP number 169 of 17, Mr. Rani Prashad.
Lordship, all default has been removed. All default has been
What is
removed.
it? What is it? Defect. Counsel for the petitioner submits that all the defects have been removed. Will stop office to check and proceed and get the case listed under the appropriate heading.
Serial number 3, CMP 368 of 17, Mr. Akshay Kumar Mahato.
Defects. 2 weeks peremptory to remove the defects.
Serial number 4, CMP 497 of 17, Mr. Sudhanshu Shekhar Chaudhary, Photo Commissioner.
My lord, in this case, my lord, my name is a but file has been taken back since long. That's why I put it into.
2 weeks peremptory to remove the defects, pending which this application will be dismissed for prosecution.
My lord, I am appearing on behalf of the estate.
Give
My
your slip.
appearance.
Send your slip. Yes.
Serial number 5, CMP number 30 of 90. Order petitioner.
behalf of the Muhammad Hakim, I wanted to take time because Muhammad Hakim has already been appointed as APP.
2
Therefore,
weeks.
in case of
2 weeks peremptory. 2 weeks peremptory to remove the defect.
Serial number 6, CMP 173 of 19, Mr. Abhijit Kumar Singh. Order
I am
petitioner.
appearing in this matter, my lord. My lord, now two defects are remaining. One is with regard to copy of the order by which the order was, the writ petition was dismissed for default to be supplied. My lord, just in this week, my lord, I have got the order.
2
So
weeks.
by Monday,
2 weeks. 2 weeks peremptory to remove the defect.
my lord, it will be removed.
Giving you 2
Okay.
weeks peremptory.
Serial number 7, CMP number 174 of 19, Mr. Alia Mato. Order petitioner.
my lord, I hope my lord,
Yes.
defects have been removed. Perhaps my lord,
Remains. As per office note, 2 defect remains. Next page. See the next page. There is a fresh transfer. Number. What about others? I'll copy of the order they are asking for.
2 weeks time.
2 weeks peremptory to remove the defects.
Lordship. All right.
Serial number 8, CMP number 288 of 19, Mr. Ashutosh Anand. Order petitioner.
My lord, perhaps all the defects have been removed, my lord.
Yes.
Perhaps all the defects,
Counsel for the petitioner submits that all the defects have been removed. Office to check and proceed.
my lord.
Serial number 9, CMP number 307 of 19, Mr. Mohammed Asadul Haq.
2 weeks peremptory to remove the defects.
I appear on of the state, my lord.
Serial number 10, CMP number 378 of 20, Mr. Pradeep Kumar Verma. Order petitioner.
No.
I pray for 2 weeks time.
On appeal लिखिएगा. Yes.
Pray for 2 weeks time.
2 weeks peremptory to remove the defects.
Or like that.
Serial number 11, CMP number 485 of 90.
All defects have been removed in this case. This case to be listed under the ring for
I
admission.
appear on of the state, my lord.
Serial number 12, CMP number 777 of 19, Mr. Ashok Kumar Pandey.
Lordship, 2 weeks time given, Lordship.
2 weeks peremptory.
Yes.
Yes.
Serial number 13, CMP number 779 of 19, Mr. Rajnikant Oja for the petitioner.
Mr. Oja, switch on your microphone. No, I can't hear you. There's some problem with your microphone. Audio device. There is some problem with your audio device. There is some problem with your audio device. Pass over. You log out and then again log in.
Serial number 14, CMP number 808 of 90, Mr. Faisal Khan for the petitioner.
Yes, anyone appearing? No one appears. 2 weeks time is granted to remove the defect peremptory.
Serial number 15, CMP number 829 of 90, Mr. Amota Chaudhary for the petitioner.
No one appears. 2 weeks time peremptory.
Serial number 16, CMP number 4111 of 90, Mr. PM Vikram for the petitioner.
No one appears. 2 weeks peremptory.
Serial number 17, CMP number 291 of 20, Mr. Rahul Kumar for the petitioner.
Milords, I tender apology, Milords, for the matter being defective, Milords. I'll cure the defects, Milords.
2 weeks peremptory.
Milords.
Serial number 18, CRMP number 471 of 20, Mr. Yogesh Krishna for the petitioner.
Lordship, I'm appearing for the petitioner in this matter, Lordship.
Yes.
Lordship,
How much time?
Lordship, 2 weeks time, Lordship.
2 weeks peremptory.
Oblige, my Lord.
Serial number 19, CRMP number 124 of 21, Mr. Vinit
Lords,
Chandra.
in this case, one defect has been pointed out with respect to earlier moved or not. Lords, may I only request, my Lords, that para 13 we have mentioned it. My Lords, it may kindly be ignored.
Para 13.
13, my Lord. Page 5.
In view of the statement made in paragraph 13, this defect is ignored. Other defects removed?
Yes.
What is this for restoration?
My Lord, this is for the restoration of the CRMP, my Lord, that was dismissed on 15/1/2020, my Lord.
Why it was dismissed?
Lord, there was a preemptive order for certain defects which were pointed out. My Lord.
When will you remove the defect?
Lord, in the next 3 weeks, my Lord, or 2 weeks,
Likhye do.
whatever Lord you wish.
Counsel for the petitioner submits that CRMP 867 of 2019 was dismissed for non-compliance of the peremptory order. He submits that due to inadvertence, the order could not be complied with. So the council undertakes that he will remove the defects in CRMP 867 of 2019 within 3 weeks. Full stop.
Yeah.
Next, for considering his submission, this CRMP is allowed, which was filed for restoration of CRMP number 5. CRMP number
867 of 19.
67 of 2019. First up, the CRMP 867 of 19 is restored to its original type.
Very much obliged.
Disposed of.
Serial number 20, CMP number 179 of 21, Mr. Sachin Kumar for the petitioner.
Your Lordship, I am appearing for the petitioner, Your Lordship. 3 weeks time may be given.
2 weeks. 2 weeks peremptory to remove the defect.
Serial number 21, CRMP 891 of 21, Mr. Ajay Kumar Pathak for the petitioner.
In this case, Lord, I have removed all the defects, Lord, except one, Lord, that is to file, Lord, with regard to whether I have moved earlier or not, Lord. That is that I am filing on Monday, Lord. I have called on my client to swear the affidavit, Lord. So only 2 days will be sufficient, not if Lordship will allow me to file. Only that, to that effect, defects is there, Lord. All defects I have removed.
Wait. This is a CRMP.
Yes, CRMP, Lord. For restoration, Lord, of one CRMP number 3611, Lord, 2019.
So paragraph 2, you have what you have stated.
Lord, that inadvertently, Lord, that has been left to state that whether I have moved earlier or not, Lord. So it is completely left, Lord. I have to file supplementary certificate as pointed out.
This case is adjourned for 2 weeks.
That's
My lord, I am appearing on behalf of the estate.
Yes, Mr. Oja, Rajnikant Oja.
Yes, my lord, I am.
Yes. How much time you need to remove the defect? 2 weeks.
3 weeks may kindly be given as because the order has not been obtained. So yeah.
2 weeks.
All
2 weeks currently to remove the defects. 2019 matter.
Under the heading for orders, serial number 23, serial number 24, serial number 25 and 26.
Made.
Number 260017, it's CRMP number 259770, CRMP number 280070, 90, it's CRMP number 2801 of 90.
One by one. Let us take it.
Made, take my lord.
This is one by one.
Yes, my lord. On instruction of Mr. Spock, Trustee, my lord, I am appearing in all
Yes.
format.
Yes.
My lord, we kindly have item number 24, your lordship.
Item number
24, item 24.
24.
Yes, ma'am. That is, my lord, criminal miscellaneous number 2597 of 2017.
597 of 17. Yes, next.
So I will give the fact first, my lord. First, the impugned order, my lord.
Yes.
The impugned order is, my lord, texture 1, my lord. And page number, your lords will find
Page number
72, your lords.
72.
72.
Yes, 72.
My lord, the heading is, my lord, the case is, my lord, this is impugned order RC 404A by 2010, my lord. This is the RC, my lord. And my lord, while this case was, my lord, charge sheet number 1 was in progress, my lord, trial, my lord, in the initial stage, this supplementary charge sheet have been filed, my lord. My lord, received supplementary charge sheet number 06 dated 29/07/13, while later 3013 A Adar dated 29 July 13, submitted by Superintendent of Police CBI Ranchi against the accused persons, namely Harinarayan Rai, Sanjay Kumar Rai. My lord, Harinarayan Rai is before your lordship, my lord, the petitioner hearing. Sanjay Kumar Rai is his brother, my lord. And my lord, and Y.N. Chaudhary, Lalan Singh, Jaiprakash, Nathuram, Philip, and my lord, under section 120B 42047 IPC, sections, my lord, under 13(2), read with 1B of the PC 1988, along with the list of witness, list of documents, sanction order, case diary. From perusal of the case record, it appears that, I know this is important, my lord. That is why I am slowly reading, that cognizance has already been taken against the accused in RC case number 0410 under section 119 IPC, read with section 13(2), 13(1)E of the PCF. So, my lord, this is a supplementary charge sheet, my lord, filed, my lord, under section, my lord, section 13(2), my lord, and 13(1)D, my lord. In a case, my lord, the Original FIR is my lord 4 my lord 510, and this is supplementary charge sheet my lord during the initial stage of the trial of this case my lord. My lord, further I will read my lord because this is the improved order. Pairing the case report as well as the case diary and document. Necessary sanction order for prosecution against the accused persons, namely, name my lord. Next paragraph, your lordship, on the basis of material available on record, I find that prima facie case.
Mr. Sanjay Kumar, there is some problem with your audio.
I don't my audio, so I have opened it, my lord. So now my lord is getting me.
Yes, now I am getting it.
So my lord,
Bit better.
So my lord, last paragraph, your lordship, because
Yes.
then I will come to the facts, my lord. So is it on the basis of material available on record, I find that a prima facie case is made out for proceedings further against the accused persons, namely Harinarayan Rai, name I will not give, under section, my lord, IPC, I did my lord, 13.2, read with 13.1D of the PCF 1998. So, my lord, now I will explain your lordship that I was already facing trial under section 13, my lord, of misconduct by a public servant, my lord. And when during the pendency of the trial, my lord, a supplementary charge sheet has been filed. My lord, naming some more accused persons, my lord. And my lord, this is the matlab ki one charge sheet, my lord, section supplementary charge sheet, my lord. Number 6 has been challenged by my lord Harinarayan Rai and his brother, my lord. So his brothers, my lord, have filed, my lord, criminal miscellaneous number, my lord, 2800 of 2019, my lord. And my lord, we find that, my lord, prior to that, that other same day, my lord, another supplementary charge sheet have been filed, my lord. And my lord will file the order, my lord, dated, my lord, in page number 73, your lordship. I will come to the facts, my lord. So same day, supplementary charge sheet have been filed, my lord, against these 3 persons, my lord, the Harinarayan, his wife Susila, and his brother Sanjay. So, my lord, charge sheet number, my lord, same day, 19th July 2013, my lord, received supplementary charge sheet number 5. So 6 was filed, my lord, that has been challenged in this petition, my lord. 5 have been challenged in other petitions separately by all the 3 persons, my lord, Susila, Harinarayan, and Sanjay. My lord, I will read it, my lord, so that I don't have to go to the other petitions, my lord. So received supplementary charge sheet number 5, dated 29th July 2013. White letter dated so and so, submitted by Superintendent of Police Ranchi against the accused persons Harinarayan Rai, Srimati Susila. Susila is the wife, my lord. And my lord, Harinarayan, Srimati Susila.
So, Mr. Sanjeev Kumar, just let me be clear.
Yes.
This supplementary, this order 29/7/2013.
Yes, ma'am.
This received supplementary charge sheet number 5.
My lord. 5 and 6 was filed in the same date, my lord, and 6 had been challenged in this petition. My lord, actually what happened, multiple petitions have been filed. Otherwise, in a single petition would have been filed, my lord. So that is why I am explaining it.
So this serial number 23 is which one?
Yes, serial number 23, my lord, is Harinarayan, my lord.
Yes. This is charge sheet number
6, my lord.
6 of 8.
Yes, my lord. Charge sheet number 6.
6.
Yes, my lord. And charge sheet number 5 is, my lord, 2597, my lord. Petition number, that is charge sheet number 6, my lord. Supplementary charge sheet number 6. 2597, the petition is before your lordship.
Item number is 23 is 2600, my lord. That is in that case.
Yes.
Charge sheet number 5 is impugn order, my lord.
Yes, that is why I'm asking this. Let there be no confusion.
Serial number 23.
So, my lord,
CRMP 2600 is charge sheet number 5.
yes, my lord, that is charge sheet
And
number.
CRMP serial number 24 is charge sheet number 6.
Yes, madam. Yes, madam. Yes. So, my lord, so I don't have to, will have to go to the all the petitions, my lord, because that will be decided simply on law, my lord. So, charge sheet number 5, my lord, same day was filed, my lord, during the, in course of a trial, my lord, was being faced by Harinarayan Rai, his brother Sanjay, and his wife Susila, my lord, that is the RC4, my lord, A, charge sheet number 1, that have already been decided. So, my lord, that's charge sheet number 5, supplementary charge sheet file number, the same, my lord, finding, my lord, by the trial court. So, my submission before your lordship is that in court, my lord, first, now I will give you the first, my lord, in the facts of this case. This is a case, my lord, in which first a complaint case was filed by Kumar Vinod, my lord. Then matter was transferred by the judicial magistrate to the vigilance court, your lordship. Then vigilance court, my lord, supplement a charge sheet was filed before the vigilance court, your lordship. And when the vigilance court was still seized with the matter, my lord, the matter was transferred to the CBI, my lord, by the Honorable High Court Division Bench, my lord. That's have been written. And my lord, division bench, once the matter was transferred to the CBI, my lord, then CBI filed a charge sheet, my lord. First charge sheet, my lord, was filed, my lord, charge sheet number 1, your lordship. And in that case, while the trial was going on, trial was in the initial stage, this supplementary charge sheet number 5 and supplementary charge sheet number 6 has been filed, my lord. So what happened, my lord? As per the law, my lord, all the 3 charge sheets should have been taken into consideration by the trial court, and there should have been a single judgment, my lord, but that was not done. So first, my lord, the supplementary, first the vigilance charge sheet was not taken into consideration, your lordship. Secondly, my lord, once there was a vigilance charge sheet, my lord, the first charge sheet, my lord, which was being tried by the Honorable Special Judge, my lord, that should have been a supplementary charge sheet under 173(8), my lord. Then, my lord, again, my lord, charge sheet number 5, my lord, should have been a supplementary charge sheet, your lordship. And charge sheet number 6 should have also been a supplementary charge sheet, my lord.
Yes.
So, my lord, as per the law, my lord, laid down by Honorable Supreme Court, my lord, in Binay Tyagi's case, your lordship, all the charge sheets should have been taken into consideration by the learned special judge, my lord, and the judgment should have been passed, your lordship.
So, in charge sheet number 1, judgment was already passed.
Yes, my lord. This is that is why, my lord, I have challenged all these charge sheets, your lordship. And, my lord, in the judgment, my lord, I had taken judgment was passed and he was convicted, my lord, and after conviction, my lord, these supplementary charge sheets are being tried. And same FIR, same investigative officer. And, my lord, in the very initial stage of trial, my lord.
No, in the first charge sheet, charge was framed under what section?
Section 13(1), section 13(2), and 13(1)(d)(e). Whatever section is there, my lord, section 13, and the IPC, my lord, misconduct by a public servant. So, my lord, first, my lord, the charge sheet number 1 should have been supplementary charge sheet in which he had been convicted.
The main charge sheet number 1 is the main charge sheet.
In which, my lord, these supplementary charge sheets have been filed. Supplementary charge sheet number 5 and charge sheet number supplementary charge sheet number 6 have been filed. So my submission is very limited, my lord. Now I have been convicted. Even if this charge sheet, first charge sheet, my lord, charge sheet number 1 is considered to be the charge sheet under 173(2) CRPC, my lord. Then these are supplementary charge sheet within the meaning of 173(8) of the CRPC. So all the accused persons were available for trial. There was no justification, my lord. There is no law that for first the learned trial judge will decide the supplementary charge sheet number, charge sheet number 1. Then, my lord, one by one he will go on deciding supplementary charge sheet number 5 and 6. In case, my lord, I have passed on the judgments to your lordship.
Just a
On
minute,
the
Mr.
last
Sanjeev
date of the hearing also, my lord,
the charge
sought clarification.
the charge sheets are filed
Yes, ma'am.
to bring out the facts of the case which constitutes an offence on basis of which charge has to be framed.
My lord, in a single charge FIR, your lordship.
So no,
What in case there was
what I'm saying.
a offence, then
There is no trial of charge sheets.
Exactly, there is no trial of charge sheet, but supplementary charge sheet, my lord, in case 10 supplementary charge sheet will be filed, then for the same offence I can't face 10 trial, your lordship. Then section is 13, my lord, misconduct by public servant. So then they will go on filing charge sheet 13(1)A, 13(1)B and 13(1)C and separate trial. There is no such law, your lordship. And first, my lord, when the vigilance charge sheet was there, then the vigilance charge sheet was first charge sheet, my lord, that is charge sheet, my lord, under 173(2), your lordship. First charge sheet filed by the CBI, CBI should have been supplementary charge sheet 173(8), your lordship. And all the subsequent reports should have been 173(8), your lordship. On the last date of hearing, I raised the same issue, my lord, and the prosecution, your lordship, had made a statement that they will come with some clarification. In a case, my lord, I have been convicted. That is a separate issue. But can I be again tried, my lord, for the same offence? And my lord, had there be a distinct offence, then they should have registered as a fresh FIR. There was no bar in course of investigation. In case the prosecution finds that a separate offence has been committed, they should have registered a separate FIR, and instead of filing a supplementary charge sheet within the meaning of 173(8), they should have filed a charge sheet under 173(2) and have started a fresh trial. There was no bar. And the same FIR. And in course of the trial, my lord, in the same charge sheet, it has been filed. In course of trial of the same charge sheet. And there is no explanation anywhere. My lord, in this regard, I have filed a judgment, my lord, by Honorable Supreme Court, my lord, Binay Tyagi, in case your lordship have found the judgment.
Yes, give me the reference.
That is, my lord, 2013. 5 Supreme Court cases.
2013.
13, my lord, bracket. 5
Yes.
Supreme Court cases.
Yes.
762. Binay Tyagi versus Ilsad Ali alias Deepak and others.
Okay.
My lord, the judgment starts, my lord, just the issue rate involved, my lord, just I will read your lordship. My lord, the issue, my lord, was raised, my lord, that starts from, my lord, page number 772, your lordship.
772.
Yes, ma'am. Exactly same issue was raised, my lord.
Yes.
Question number 1. Whether, my lord, found it? Question number 1, my lord. 1.1. Whether in exercise of powers under section 173 of the Code of Criminal Procedure 1973 or sought the trial court has the jurisdiction to ignore any one of the reports where there are 2 reports by the same or different investigating agencies in furtherance of orders of a court. So, my lord, in this case, my lord, there are 4 reports. First by the vigilance, my lord. Second by and 3 are by the CBI. First was ignored by the trial court, my lord. Second should have been report under 173(2), my lord. When that was being tried, my lord, two charge sheets will again a supplementary charge sheet number 5.
How do you say the first one was ignored?
Yes, my lord, the judgment, the trial court have passed the judgment. I have challenged it in the High Court, and that finding by the Honorable High Court has come. Just, my lord, the finding by Honorable Mr. Justice, my lord, A.K. Chaudhary, paragraph 38, your lordship.
Where is the finding?
In paragraph 38, my lord. Of the my lord, the judgment of the trial of the High Court have been filed, my lord. Green Ryan's case, your lordship.
Page number?
फाइल किया है रजनी जी?
ऑनलाइन हम लोग भेज दिए हैं
हाई कोर्ट वाले ना?
हाई कोर्ट का ये क्रिमिनल अपील नंबर
हाँ 100 यस मैम
तुरंत भेज दे रहे हैं तुरंत भेज दे रहे हैं
My lord, in paragraph 38 of the my lord judgment by the Honorable High Court, my lord. So far as the contents of the appellants that the courts, while its order dated 4/8/2000 did not quash the charge sheet filed by the Vigilance Bureau, hence the charge sheet submitted by the CBI ought to have been treated as a supplementary charge sheet under section 173(8) of the Code of Criminal Procedure, and not as the charge sheet submitted as de novo investigation. It is fairly submitted by the learned counsel for the appellant that he does not have the copy of the order dated 4/8/2010, the petition number itna. This ground was never agitated by the appellants before the trial court. It is not disputed that while it is order dated to 4/8/2010, the petition 44700 itna, the order, the re-investigation of the case. That is not fine. I have filed the my lord division bench order, my lord. That is not re-investigation, my lord. So on that time, on that day, my lord, I was arguing online, my lord. I could not, because this order is a part of the judicial record, my lord, division bench, my lord, which directed the further investigation, my lord. I have filed this, my lord, order of the the said order dated 4/8 in W has not been brought on record of the appeal. Under such circumstances, this court is of the considered view that the ground is not open to be agitated for the first time in the appeal. So, my lord, this ground, my lord, I am challenging now, my lord. That is a finished chapter, my lord. So, two submissions are before your lordship. That this ground I am taking, my lord, not in appeal, my lord, in course of trial, your lordship. First, and second, my lord, I have brought on record, my lord, the division bench order, my lord, now. That, my lord, the investigation ordered by the Honorable High Court is not re-investigation, but further investigation. So, supplementary charge sheet filed by the charge sheet filed by the vigilance, my lord, was a charge sheet, my lord, within the meaning of 173(2) CRPC, my lord. So, first charge sheet also, my lord, is a supplementary charge sheet, my lord, and further, my lord, charge sheet number 5 and 6 are also supplementary charge sheets, my lord. So, my lord, once I have been tried in first charge sheet, supplementary charge sheet, my lord, charge sheet number 1, there is no justification, my lord, that I will be tried for the misconduct, my lord, in a supplementary charge sheets, my lord, 2 supplementary charge sheets. And my lord, the judgment is very clear, my lord, in this regard. And my lord, we have section 300, my lord, of CRPC also.
No, that means what you are saying, Mr. Sanjeev Kumar.
My lord.
That means how many times charge was framed against you?
Actually, legally, my lord, actually, there should have been only one cognizance, my lord. Cognizance can't be taken twice for the misconduct, my lord. So in case, my lord, the trial court is to be, my lord, appreciated, then thrice for the same offense, the cognizance has been taken against me.
Cognizance is taken against an offense.
Yes, my lord.
Then, on basis of the material, the accused is issued summons and proceeded against. Then, then charge is framed.
Charge is framed.
The charge has been framed only once against you.
Charge was framed once, my lord. I have been convicted.
Convicted. Now
the charge has been framed in supplementary charge.
Now, what has happened after filing of this supplementary charge?
Now the court have separately in charge sheet number 5 and charge sheet number 6. They have been separately charged me and the proceeding.
Again a charge.
Same RC. Same RC. That is why, my lord, on the last date of hearing.
Again a charge has been framed.
Yes, my lord. Again, my lord, Mr. Rusdi will as per my lord.
Again a charge has been framed.
Yes, my lord. Mr. Rusdi just make a statement before the court.
1 minute after 2 minutes. Just I am verifying, my lord. Order sheet is here, my lord.
Trial is going on, my lord.
That means in your case, charge has been framed 3 times.
Actually, my lord, it is better, my lord, that the statement should have been made by Mr. Rusdi, my lord.
It will just take some time. I have to contact to the conducting lawyer at in civil court, my lord.
This is the main issue.
So,
yes, in a particular trial, after conclusion of a trial, again a charge can be
again, my lord. This is the main issue.
This is the main issue. Yes. For which the best procedure is you bring on record the 3.
No, my lord. I supplementary affidavit would be filed, my lord, within 1.
Charge, Mr. Rashidi, charge is framed. Charge is explained first, and then before framing, and it is incorporated in an order sheet, the form of charge. So you mean to say this procedure was conducted thrice? This
exactly, my lord, exactly.
That means there should be 3 form of charge.
For the same offense. रश्मि साहब एक काम कीजिए, जो चार्ज अगर फ्रेम हुआ है ना,
सप्लीमेंट्री एफिडेविट हम फाइल कर देंगे, वो तो इसमें रिकॉर्ड में हम ले आएंगे, कोई भी चीज और बिना रिकॉर्ड में लाए
चैलेंज क्यों किए हैं? तो इसको चैलेंज कैसे किए हैं अगर चार्ज नहीं चल रहा है?
अगर चार्ज नहीं चले तो चैलेंज कैसे किए हैं?
तो इसलिए वो चार्जेस का जो ऑर्डर है उसको ये कीजिए।
हाँ, हम एनेक्ट करें, रिकॉर्ड में ले आते हैं, जो
हम ले आइए, और ये जो हाई कोर्ट का ऑर्डर है उसको भी रिकॉर्ड में फाइल कीजिए, बिना याचिका के ऑर्डर रिकॉर्ड में फाइल कीजिए।
Who is appealing for the CBI?
Yes, madam.
Appearing, my lords.
Yes.
The office of ASJ representing CBI, my lords.
Yes.
My lords, it seems that we have not filed our counter also, my lords, in this present case, my lords. So, my lords, 2 weeks time may be granted, my lords, so that.
Just tell me, have you understood?
Yes, my lords, I have understood. Yes, my lords, I have understood. There is one FIR that has been lodged against couple of people.
One FIR. See, one FIR, first charge sheet has been filed against this petitioner.
My lords.
Forget about whether by CBI or whether by ACB or anyone. First charge sheet filed, keeping the investigation pending, maybe. Then, in the meantime, charge was framed.
My lords.
This petitioner has been convicted.
Yes, sir.
Again, another charge sheet filed.
Supplementary charge sheet, yes.
In the same case, the same transaction, again a supplementary charge sheet filed. Again, he has been explained charge. Then, as per him, he is facing trial. Charge has been framed and he is facing trial. Trial of what?
Yes, obviously, if the trial has already been done against the same accused person, against the same section, my lords.
Now, see if the criminal case is FIR is, it's only one trial. That has to be only one trial.
Yes, my lords.
Now, in one trial, in 13-2, he has been convicted, say suppose for 3 years, 5 years. In first charge sheet. Now, in the second charge sheet, he will convict him again for 5 years for the same offense.
And third also, my lord.
No, First and the foremost, my lords, whether we have to.
If the trial would have been delayed and would have been conducted after submission of all the charge sheet and the supplementary charge sheets, then conviction would have been only for 5 years.
Yes, sir.
Or the maximum number what is there?
Yes, my lords.
So can you say that, suppose if the maximum years of term of punishment is, suppose in a particular case is 10 years,
My lords.
and while trying in the main charge sheet you convict him for 10 years, then a supplementary charge sheet file, can you again convict him for 10 years?
No, section 30 bars me from doing that, my lords.
Then what have you done? You just seek instruction on this point also.
Indeed, my lords. Indeed, my lords. I'll do that.
और रजनी साहब इस बीच में फाइल कर दीजिएगा जो
Keeping it after 2 weeks, 3 weeks. List this case after 3 weeks.
Much
As, Mr. Rashidi wants to file a supplementary affidavit annexing some important documents.
Yes, ma'am. In all 4 cases, ma'am. 3 cases, ma'am.
All cases. The charge is, if a joint charge, if on a particular date a charge has been framed against all the person, you bring that record. That will be
Yes, ma'am.
Yes. Much best.
Yes.
Serial number 27, CMP number 589 of 19, Mr. Miss Saroj Kumari.
What is the CFP? Who is appearing? Who is appearing? Unmute yourself.
I'm appearing on behalf of the state.
No one appears. Adjourn for 3 weeks.
Serial number 28, CMP number 892 of 19, Mr. Ajay Kumar Pathak.
No one appears.
Serial number CMP number 171 of 20, Mr. Ali Aditya.
Lordship, this petition has been filed for restoration of the SA number 23 of 2018, Lordship. All defect has been removed, Lordship.
The IA is for?
IA for condoning of delay, Lordship.
The second appeal was dismissed.
Yes, Lordship.
Issue notice on the IA and the main application. On respondent number 1 to 13. Ordinary process requisites 4 weeks.
Oblige, Lordship.
Under the heading for admission, serial number 33, CMP.
My lord, I appear on my lord, serial number 32, my lord. BA matters, my
BA
lord.
matters, have you not gone through the notice which has been published? Or you
My lord, network problem. I could not appear, my lord, on time.
What was the time?
My lord, 2:30.
2:30, have you not gone through the notice?
2:15.
It was 10:30. The notice clearly says all the bail matters will be taken up at 10:30.
I'm sorry, my lord.
It was called on 10:30, no one was there. 2:15 it was called, no one was there. So order has been passed and it has been dictated also and typed also.
Lordship 31.
31 also.
30 only.
Don't go through the notice, so you face the consequence. After 2 weeks, all matter has been adjourned after 2 weeks.
Obliged.
The council who has gone through the notice, they appeared. First of 10:30, council appeared. Nilesh Kumar also appeared.
नेटवर्क प्रॉब्लम के कारण नहीं ज्वाइन कर पाया था
हाँ?
नेटवर्क प्रॉब्लम के कारण नहीं ज्वाइन कर पाया
मुझे
था
नेटवर्क प्रॉब्लम था 10 बजे या 9:15.
If may allow, I am ready, Lordship.
No, sorry. Order has been typed in the order sheet. Yes, next. Yes, who is appearing? CMP 11 of 17. Who is appearing? Mr. Prashad? No one appears adjourned for 3 weeks.
I am appearing for the state, Your Lordship.
No one appears for the petition.
Serial number 34, WP Kimball 372 of 17, Mr. Shesh Gautam.
Yes, my lord. I am appearing in this case, Your Lordship.
Yes.
Your Lordship, in this case, Your Lordship.
Your Lordship, I seek your permission to say something.
Yes, yes.
My Lordship, I was at serial number 39, which is to be started from serial number 35. So I am there to hear. Yeah, Lordship.
31, which was not, this is 30?
34, this is.
34.
Oh, 30. Oh, sorry, Your Lordship. Actually,
yes.
Yes, my lordship. In this case, Your Lordship, earlier a police case was registered. And thereafter the case was transferred to the vigilance for the same set of allegations, Your Lordship. Thereafter a vigilance case was also registered. And my grievance is, Your Lordship, in both the cases trial is proceeding, Your Lordship.
Yes.
And on last occasion, Your Lordship, a counter has been filed. Recently, a counter affidavit has been filed. May kindly see, Your Lordship, para 9. The counter affidavit. It has been stated that there cannot be two trials of the case when the case has been transferred to the Vigilance Bureau. But nowhere has it been stated, Your Lordship, and if any step has been taken by the state or by the vigilance to stop one trial.
My lords, I am appearing for the state, my lords.
There is re-registration of the FIR, you are saying?
Yes.
So when there is a re-registration FIR, what happens to the original FIR?
Trial is proceeded. Trial proceeded, Lordship, in that case also.
Yes, Mr. Srinu.
My lords, the trial should not proceed, my lords, but in this particular case, it has been proceeded.
Why the trial is proceeding?
My lords, at that time, they have not filed any application for calling for the records before the vigilance court, my lords. After filing of this affidavit, they have filed an application before the vigilance court for calling of the records, my lords.
Who has filed?
The earlier, the vigilance department, per the instruction, vigilance has filed, my lords. My lords, for vigilance. Sorry, my lords.
The record has been called for.
They have filed an application, my lords, but we have not received any instructions, my lords.
You just communicate the order which was filed, which has been passed. Any order passed? By the way.
My lords, I have not received any instruction from the vigilance. Ms. Priya Shrestha madam is the advocate for the
Yes,
vigilance.
no, any instruction has not come from vigilance department.
Just tell me, how can there be two trials?
Yes, Your Lordship. There cannot be two trials.
Then
They have to file a petition for calling of the record, Your Lordship.
you have filed it.
Yes, Your Lordship. But there is no instruction that any order has been passed by the trial court, Your Lordship.
Seek instruction.
Lordship. Lordship.
Seek instruction and try to get an order next week. Raise this case next week on the request of Priya Shresht and Srinu Ganpati.
My lord, after 2 weeks, my lord.
2 weeks, Your Lordship.
From this court
Obliged.
as to what steps either of their clients are taking to prevent continuation of two trials in arising out of the same offense.
Obliged.
Obliged, my lord.
Yes.
Lordship, I seek your permission, Lordship, that in serial number 35, along with that, with at serial number 39. Yes, yes. Pardon, Lordship?
The case has not yet been called out. Let the case be called out. Wait.
Oh, sorry, I could not hear it, Lordship.
Serial number 35 with serial number 36, 37, 38, 39, 40, 41, and 42 with 43.
Yes. Yes. What do you want to say?
Lordship, first of all, I seek sorry and for intervening in between. I could not hear it properly. Lordship, secondly, Lordship, I want to make a submission. On last occasion, last date, on 11/3/2022, your Lordship was very much pleased to give me an opportunity that I should file a short notes on my locus standi and on maintainability of the intervention application,
yes,
which I have filed IA in CRMP number 1149/2012. My IA number is 1106/2019. That has been filed by one of my petitioner, Miss Kavita Lakhotia, who is widow of Gopal Lakhotia, late Gopal Lakhotia. My lord, as per your directions, my lord, I have filed my short notes and my maintainability aspect. Due to personal constraints and everything, I tried my best to place before your lordship in order to satisfy this court.
Yes.
My lordship, the moot question which arises here, I have divided it into two parts, my lordship. My locus standi.
Where is that petition?
My petition is IA number 1106/2019, your lordship.
In which case?
In CRMP number 1149/2012, Vijay Kumar Singh. 11 CRMP number 1149/2012.
114, serial number 39.
Vijay Kumar Singh is the petitioner.
In this case, you have filed an intervention only in one case.
In only one case. Since I am affected by this builder only, my lordship, this petitioner.
Okay.
In this only I have filed that IO 11064 only.
11064. What is the? Yes.
On last occasion, you have directed me, your lordship. You have availed me an opportunity.
11064. IA 11064.
Yeah, lordship.
Yes.
On last date, my lordship, I was being directed to file a short notes of argument only on the point of maintainability of intervention application and locus of the intervener.
Yes.
My lordship, with all humbleness, I want to submit before you. Yes. I have tried my best so that I can place before certain judgments before you, and within that time, my lord, I could have come with two new judgments which have been filed at my lordship. One at para number one judgment new. There are two judgments. I am not quoting the earlier judgments, my lordship.
Yes.
That is the new judgment is at para number 17 of my short notes.
17.
One seven.
Yes.
that is in Delhi Domestic Working Women's Forum versus Union of India, 1995 1 SCC 14. The
Yes.
Honorable Supreme Court, giving parameters with respect to assisting victims of rape, held that it is important to have someone who is well acquainted with the criminal justice system. The role of victim's advocate would not only be to explain to the victim the nature of proceeding, prepare her for the case, and to assist her in police station and in the court, but to provide her with the guidance as to how she might obtain help of a different nature. The court said it is important to secure continuity of assistance by ensuring that the same person who looked after the complainant's interest in the police station represent her till the end of the case. This could be interpreted to mean that an intervener be allowed to assist the victim. Now, my lordship, with your due permission, para number 18, that the Honorable Supreme Court went a step further in JK International versus State, Government of NCT of Delhi, 2001, 3 SCC 462, and stated that a third party's role is not negated by CRPC. The recent trend has been to allow for participation by those affected in the criminal justice delivery mechanism for the ends of justice. That Section 397 CRPC empowers the High Court or the Session Court to call for the record of any proceeding before any criminal court inferior to it to satisfy itself as the regards the correctness, legality, and propriety of any finding, sentence, or order recorded or passed by the lower court. The court can examine the intention of the party seeking to intervene and her bona fides, and may allow intervention in criminal matters as respondent who will be assisting the court in adjudication of the case in interest of justice. And coming to para number 9, my lordship, so that it is therefore most respectfully, sorry, my lordship, before that I want to place one CRPC provision is there, my lordship. I want to place that. My lordship, I am the aggrieved person, I am the victim, I am the person who has got legal and other rights situated with this case. I am being directly attached to the subject matter of this case. My lordship, coming to section 24(8) of CRPC. My lordship, with your permission, I am reading section 24 CRPC 24(8). 24(8). Under 24(8) is said, my lordship, the court of God, provided that the court may permit the victim to engage an advocate of his choice to assist the prosecution under this subsection. My lordship, in this regard, I will like to place one more judgment which has been left out. Due to haste, I could not file before your lordship. I may be permitted. That is very relevant judgment, my lordship.
Yes.
I would like to bring before you, with your all due permission, my lordship. Lordship, section 302 of code has been interpreted in many cases, my lordship. In Dhariwal Industries Limited, Honorable Supreme Court AIR 2016 SC 4369 explained the distinction between section 301 and 302 CRPC. The role of the informant or the private party is limited during the prosecution of a case in a court of session. The counsel engaged by him is required to act under the directions of public prosecutor. As far as section 302 of CRP is connected, power is conferred on the magistrate to grant permission to the complainant to conduct prosecution independently prior to criminal. My lordship, prior to Criminal Law Amendment Act 2009, the situation is different with regard to interference of third parties in criminal trial. The private person or private counsel can be permitted to assist the prosecution under section 301 CRPC in cases trial by court of session. Now the thing is different, my lordship. Section 24(8) proviso amendment in Code of Criminal Procedure Amendment Act 2009 and allowed the third party, including de facto complainant, to prosecute their own case. Your Lordship, one more case judgment is there in Delta Car Private Limited versus Sanjeev Shah. Honorable Court held that a de facto complainant, a victim, even in bail application, can be permitted to come on record as co-respondent either to assist the court or assist the PP as the case may be, and even before the wording of Section 24(8) provision of CRPC Amendment Act 2009. Lordship, one more thing is that another case is also there in Srimati Mahabuniasa Begum versus State of Telangana and two others, 2017, in criminal petition number 7108 of 2017 by Honorable Sri Justice B. Shiva Shankara Rao, gave order by citing the decisions AIR 2016 SC 4369, comma, AIR 2001 SC 1102, comma, 2015 bracket 2 ALT CRL 216, another AIR 1959 SC 375, and criminal PNO 5674 of 2015 dated 26/6/2015 allowed the criminal petition moved by the de facto complainant in a case crime registered under section 498 of IPC and section 3 and 4 of DP Act. In this case, the magistrate, my lord, here is to point to be noted. In this case, the magistrate dismissed the petition under section 302, read with section 24(8) of CRPC, to permit her to prosecute through private advocate. The magistrate had dismissed her petition. The order of the magistrate dismissed and allowed the petition of complainant, saying section 302 CRPC is not applicable to the magistrate, is unsustainable. So also in ignoring section 24(8) read with section 2WA of the amended CRPC, which further recognizes the right of the victims in recognizing the scope of section 301 of CRPC is only limited when compared to scope of section 302 and section 24(8) of provision read with section 2WA of CRPC. Honorable Justice of Supreme Court cited decision of Honorable High Court in Gudi Bhavani Sujata versus Muglua Srinivasa Rao. It was held that either under section 302 CRPC or even under section 24(8) proviso of amended CRPC, magistrate could got power to permit the victim or the de facto complainant to conduct prosecution by participating in the proceeding by engaging the private advocate. Your Lordship, this is the things I wanted to bring before you. हुजूर, मैंने इतना मेहनत किया है to in order to satisfy you. I hope I could make it out. My lordship, I am directly connected with the subject. They have made a forgery, and after playing a fraud, half of the parking space which should not have been sold, that has been sold by the builder, and that has been purchased by it. So selling and buying also is an offense. Moreover, a misrepresentation, by playing misrepresentation, they got a map sanction from RRDA. For that cancellation of that said very map, which Mr. Vijay Kumar Singh in his name has got map sanction, I have filed a WPC 779/2020 before this Honorable High Court, which is still pending. RMC has till date, they have not cancelled that sanction map. Though sumoto they should have done it. But in spite of that, I've been run from here to there, but they have not cancelled it. Finding no other way out, I have filed a WPC 779/2020 against that builder only, which is lying pending. So all my rights, legal rights, has been infringed, my lordship. And earlier, in my your lordship, in my in that short notes of argument, I have already, as in last time, I have read before your lordship that my constitutional legal rights have been infringed, and in that case, I have submitted one the judgment of Chamele Singh versus State of UP 1996 to SCC 549. A bench of 3 judges of Honorable Supreme Court considered and held that right to shelter is a fundamental right available to every citizen. It was read into Article 21 of the Constitution. My lord, another judgment I want to place before your my lord, that is of Supreme Court. Supreme Court has upheld the order of Bombay High Court, saying that the parking space, which is meant for common purpose of all the resident of that very apartment, cannot be sold by the builder. They are part of the common areas, and cost of the land has to be charged to all flat owners in proportion of the carpet area. That said judgment is, your lordship, Nahal Chand Lalu Chand Private Limited versus Panchali Cooperative Housing Society Limited, JT 109 SC 414. And another judgment, your lordship, I want to place before you, your lordship, that is with respect to that is with respect to fundamental rights. In this, Supreme Court has told when the fundamental rights has been infringed, in spite of having alternative remedy, I hope Honorable High Court is the can only restore by that. For that purpose, I am come here, my lordship. Where there is failure of principle of violation of natural justice, or where there is writ petition for the enforcement of fundamental rights, under such decisions I have come. Or under 2WA CRPC, I am the victim, I am the aggrieved person, my lordship. I am a widow of late Gopal Lakhotia. My husband had died. During this course of this, when the case was going on till this, I was running from pillar to post to get cancel the map. It was not cancelled. My late husband has also paid RMC. RMC says it's their prerogative. It's their prerogative what to cancel, what not to cancel. In spite of having provision of cancellation of map, the map has forced it to be cancelled immediately if it is brought before the RMC and RRD authorities. They haven't cancelled, my lord. Till
Okay,
date.
I have understood your case. Yes,
Okay.
who is for the petitioners? Who is for the petitioners?
In this case, Mr. Neeraj appears where he has filed the intervention.
Yes.
Well, in case he has filed the intervention petition, Neeraj is an advocate of the court, Mr. Pandey Neeraj. In this
Who
case.
will argue for the petitioner?
Well, I appear for item number 35, 36, 38, and 41.
Yes, what is under challenge?
Initially, order taking cognizance was challenged, and in that case, the beneficiary, in case of beneficiary, the cognizance was set aside by this honorable court, and then against that, the CBI went to the Supreme Court, and when at the framing of charge, when we raised this issue, that no cognizance survives, that has been dismissed, and the charges have been framed, This is the
No, the Honorable Supreme CBI has gone to the Honorable Supreme Court.
Yes, my lord. That
What
is
happened there?
They are self-dismissed or dismissed.
In which case?
Lords,
Against whom?
Lords, against the beneficiary, whose building was alleged to be sanctioned by us, my lord. We are the officers of the RRD, my lords. We sanctioned the map, we processed the map, my lords.
Sanctioned the map?
Yes, my lords. It was sanctioned as a signature of vice chairman, my lord, but we are the officers, my lords.
No, just tell me. Just tell me. Whose prayer has been quashed? Whose application?
Lords, the beneficiary, the builder, and in whose name, my lords, the Hotel Lilac, my lords, was the building, my lord, and Mrs. Eslesa Corporation was the, my lords, the promoter and the builder, my lords.
That person is not before me.
Yes, my lord. His cognizance was quashed, my lord. We were co-accused in that case, my lord. We are co-accused. We are allegation the charge sheet.
In this case, which is the order which is under challenge?
So order dated by lords.
What is your case?
Mine is second case, my lords, item number 36.
Yes, item number 36. What is the order which quashed
Lords,
the proceeding?
Lords, Annexure 6, page 56, it is my lord, order taking cognizance, my lord, 25/10/2011.
Annexure
6 of the writ petition, my lord, page 56. This was, yes, my lord.
No, this is the order.
Yes, my lord, order taking cognizance, my lord.
Where is the order of the High Court which quashed?
Lords, that is, we have, that can be seen, my lord, in the first writ petition, my lord, that is criminal writ petition 466, my lord.
Criminal Writ 466.
2017, my lord. That is at page 134 and Annexure 10, my lords.
134.
Yes, sir.
Yes, which for the CBI?
In this case, my lords, Mr. Prashant Pallav won't be able to assist your lordship on behalf of CBI because, my lords, earlier Mr. Pallav has appeared on behalf of the accused in the Learned Lower Court below. So we have handed over this matter to the ministry concerned. Ministry will be appointing another person in this particular case, my lords. On the earlier occasion, also, my lords, Mr. Prashant Pallav has appeared and has revealed this particular fact. My lords. We only pray, my lord, let it be after 2 to 3 weeks, my lords.
So this was order dated 18 to 2022. It's 2 months, he couldn't arrange any lawyer.
We are very sorry, my lords. But we have already conveyed to the concerned ministry that we won't be able to assist the Honorable Court in this particular matter. And the matter is being taken care by the ministry, my lords. They will be appointing someone, my lords, sooner, my lords. That is the only problem, my lords.
Your Lordship, I seek your permission to say something. Your Lordship, the learned CBI court has taken the cognizance on 25/10/2021 itself. And since then, under Prevention of Corruption Act, also the public servants have been booked 13 1D, 13D. Or after that, also they have taken consecutive two stay orders. And after that period, Your Honor has vacated that stay. And last, I think, last before earlier order, Your Honor has said that now there will be no more stay. The trial should go on. And one or two victims has been witnessed. Trial is going on. Abhi gawahi
Give
chal
for
rahi.
some time. Let they are praying for some time.
So kind of Your Honor, as you feel.
On the request made on behalf of Mr. Prashant Pallav, this case is adjourned for 3 weeks. Make arrangement, Mr. Counsel.
Yes, my lords.
Obliged. Lord. I am in serial 42, my lord. Badge office.
Next.
Serial number 44, Criminal Division 684 of 18, Mr. Samir Saurabh for the
My lord, I am appearing in serial number 44, Lordship.
Yes.
serial number 45, Criminal Division 708 of 18.
My lord, I filed this revision, Lordship, for setting aside the order dated 27th April 2018 by which the discharge application of the petitioner was rejected.
27th of?
27/4/2018, Lordship.
Yes, let us read. Who is appearing for the state?
CBI, Lordship.
CBI?
My lord, I am appearing on behalf of CBI.
Okay.
My lord, I have heard this case at length on the last date. My lord, I have directed the CBI to bring on record that on what basis they have made the petitioner accused only on the basis of conspiracy. What are the material which prove that he has entered into the conspiracy, Lordship?
Yes.
My lord, in this case, we have sought instructions from CBI, and certain documents I will like to place from the case diary, my lord.
Yes.
If my lord may come to the tender proceedings that took place on 29th of March 2004, my lord.
You have got the case diary?
My lord, I have got excerpts of the case diary, my lord.
What was the case? This is a purchase of machine.
OMR machine, my lord.
Lord, may kindly see the charge sheet, the case will be clear, Lordship. The relevant starts from page 51.
51. You are the?
I am the Lordship. I am the one of the director of SPS International, which supplied the OpScan machine, Lordship.
Okay.
My lord, I've got the page 51, Lordship.
Yes.
Lord, from second paragraph, I am just reading, Lordship.
Yes.
It was alleged in the FIR that A, the accused public servant with Dilip Kumar Prasad, the then chairman, Dr. Santi Devi, Sri Radha Govind Nagesh, both then members, and Srimati Alice Urasarani, the then secretary JPSC Ranchi, entered into criminal conspiracy among themselves and with the private firm SPS International Limited, 302B Santnagar, east of Kailash, New Delhi, and in persons of the said conspiracy purchased two optical mark reader scanning machine from the said firm, even though the price bid of another firm, the MS Methodex System Limited, with higher and better capability was lower, causing a wrongful loss of rupees 16.2 lakhs to JPSC and corresponding wrongful gain to the accused firm. D. That in furtherance of said conspiracy, the order of printing of OMR application form for second JPSC civil service examination was placed with MS-SPS International Limited by manipulation of the terms and conditions of the tender notice to suit the offer of the aforesaid firm. Further, the orders of printing of OMR sheet was placed with aforesaid firm without calling any bids and at a very high rate at least 5 occasions, causing wrongful loss of rupees 12.46 lakhs to JBSC and corresponding wrongful gain to them. The allegation at A could be substantiated, whereas the allegation at B could not be substantiated. Investigation disclosed that accused Dilip Kumar Prasad was the chairman Jharkhand Public Service Commission Ranchi during the relevant period. Accused Sudhir Jain was the director and accused Surendra Kumar Jain was the chairman cum director CMD of MS-SPS International Limited New Delhi during the relevant period. Investigation disclosed that a draft tender notice proposal dated 5/3/2004 for purchase of one of a high potential OMR scanner machine with 5,000 seats per hour scan rate and other requisite specification for JPSC Ranchi was initiated by Sri Sarvendu Tathagat, the then secretary in charge JPSC on 5/3/2004. Said Sri Sarvendu Tathagat had only specified the basis of salient features of the machines without any brand name. The said draft tender notice proposal was put up for approval by accused Dilip Kumar Prasad, chairman JPSC, but with dishonest intention, accused Dilip Kumar Prasad and by abusing his official position made a specific modification alteration in his own handwriting on the said draft and mentioned that 2 instead of 1 OMR scanner and OpScan 6/50 and OpScan 10/60 brand to be purchased without assigning any valid reason. As to why 2 instead of 1 machine and OpScan brand scanner machines should be purchased, whereas other machines with better features and capabilities were available in the market. Said accused Dilip Kumar Prasad with dishonest intention further added in the final of the said draft that the supplier must be the original distributor and manufacturer, but in fact there was no proposal form.
Case diary.
Constitutes
Case diary is not there.
My lord, I think by last previous orders, case diary was called upon and received by the honorable court, my lord.
No. Who is appearing in another case?
Hemant, unmute key.
My lord, I represent Surendra Kumar Jain, my lord, in criminal revision number 708 of 2018.
Where is the case diary?
Lord,
Case diary is with the CBI lordship, surely.
This case diary was not called for.
My lord, I'm checking the past orders, my lord. Just
Case diary was with you.
case diary is probably with CBI dispensers.
Yes. What are the material against this person, which I want to know?
my lord, in such circumstances, if the copy of case diary is not with the honorable court, my lord, then I pray that 1 week time may be given. Will submit.
I'm keeping this on a physical hearing date. It will be better.
Yes, but it
My
will be
lord.
better.
The request of the parties, this case is listed on a physical hearing date. Just show me the paragraphs and read the paragraphs where there is an overt act of this petitioner which constitutes an offence.
With regard to conspiracy, my lord, assistance was to be given by the CBI. My lord, your lordship was kind enough to direct the counsel for the CPI
CBI, I'm telling this to the CBI counsel only.
Yes, yes.
My lord, a small prayer. Appearance of Mr. Prashant Pallav for CBI may be recorded.
Is he before me? Tell me yes or no. One word answer.
Then my lord, Shivani
What is your name?
Shivani Jaluka, AC to Prashant Pallav.
AC to ASGI.
Yes, yes. Obligement.
Yes.
Serial number 46, Criminal Division 1342 Mr. Kumar Basant Narayan, Mr. Anjani Kumar, hold the petitioner.
Serial number 46. Yes. Who is appearing? No one appears after 3 weeks.
This
No one
case
appears.
of Mr. Amit Kumar Das, Your Lordship.
No one appears on behalf of the petitioner. Yes, next.
Serial number 47, CRMP number 4168 of 80, Ms. Chandana Kumari, Mr. Vijay Kumar, hold the petitioner.
Yes, my lord, I am appearing in this case, my lord. My lord, in pursuance to your lordship observation, my lord, I have filed a supplementary affidavit, my lord, by which, my lord, the order passed in the writ application and the LPA that has been brought on record, my lord. The matter your lordship will make consider, my lord, this is a case under the provisions of the IPC, my lord, so far and the PC Act, my lord. The petitioner, my lord, he was posted as circle officer at the relevant time, my lord, in the year 1991. My lord, so far as the case is concerned, well, it was a case, well, so far as the land is concerned, well, it is situated in Bargaon in the circle of the Nampu Malot, where Malot, the ex-landlord Haricharan Sahu Malot, he has executed Malot, so far as the Hukumnama is concerned, Malot, in favor of Bhagwati Devi and Durga Prasad Agarwal Malot, and settlement was made. Subsequently, the land was sold to Simalo Devi Malot and Bhagwati Devi in the year 1956 Malot. These were the transaction Malot. Malot, the mutation was made, Malot, in the year 1975-76, Malot, the rent receipt was stopped to be issued, Malot, whereupon, Malot, a proceeding under 4H was said to be initiated. Thereupon, Malot, on 21/4/1980, Malot, the observation was made with respect to the land in question, Malot, that the position...
What is your prayer in this application?
Malot, quashing of the entire criminal proceeding.
FIR, quashing of the FIR.
Cognizance has already been taken, Malot.
So, no, you have prayed for quashing of FIR in this case, or taking cognizance.
Cognizance.
Order taking cognizance.
Order taking cognizance on all subsequent proceedings. All the co-accused persons' case has already been allowed by Malord Annexer 4 onwards. Even Malord supplementary affidavit I have brought on record, Malord, the co-accused persons' case has been closed by this honorable court, Malord. Several accused persons' case has been already closed, Malord.
What is the stage now?
Malord, the matter is pending for framing of charge, Malord.
Charge has not yet been framed.
To the best of my information, Malord, it has not been framed. Malord. The 4H proceeding was subsequently, my lord, the petitioner has made a report that the 4H proceeding is not maintainable, my lord, which was affirmed by the SDO, and subsequently, my lord, on the basis of the direction given by the Deputy Commissioner, 4H proceeding was initiated, which was challenged in the writ petition, my lord. The writ petition was allowed in favor of the landowner, my lord. LPA was dismissed, and thereafter, my lord, so far as the finding which is being said to be given by the CO, my lord, that has been affirmed by the Honorable High Court also, my lord. On 14/11/1990, my lord, the petitioner has made a report when it was asked for by the LRDC. Then, my lord, the matter was reported to the LRDC, my lord, with respect to the fact, my lord, so far as the proceeding under 4H is concerned.
Who is for the ACB?
Yes, my lord. I am for the CB, your lordship. From the FIR itself, your lordship, the offence is made out.
Read the FIR, Mr. Anil Kumar.
Yes, lordship. Page 24 में लॉर्ड।
Yes.
भूमि घोटाला परिवाद संख्या 16 के संबंध में जांच कार्य मुझे सौंपा गया। परिवाद 16 के अंतर्गत आरोप है कि ग्राम बरगावा खाता नंबर 87 गैर मजूरा प्लॉट नंबर 4 एवं 5 जिसमें करीब 38 एकड़ जमीन सन्निहित है। इस मामले में गंभीर अनियमितता बरती गई है। भूमि सुधार अधिनियम की धारा 4H के अंतर्गत सभी जमीन पर निर्णय की शक्ति राज्य सरकार को निहित है, लेकिन जानबूझकर इस मामले में घोर अनियमितता बरती गई और भूमि सुधार उपसमाहर्ता ने अपने स्तर से ही निर्णय लेकर मामले को रफा दफा कर दिया। इस मामले में संबंधित जमीन सरकार की करोड़ों रुपए की संपत्ति है जो नामकुम बाजार की मुख्य भूमि है। उपायुक्त छोटानागपुर दक्षिण छोटानागपुर प्रमंडल रांची ने अपने पत्रांक दिनांक 26 दिसंबर 1994 में दोषी पदाधिकारी के विरुद्ध कार्रवाई के लिए राजस्व विभाग को लिखा, परंतु राजस्व विभाग को 50,000 रुपए देकर मामले को दबा दिया गया। जांच से सारी बात साफ हो गई। उपरोक्त आरोप पार्डन लॉर्ड,
परंतु राजस्व विभाग को 50,000 रुपया देकर मामले को दबा दिया गया है।
जांच में ये सब बात साफ हो गई।
हो जाएगी, हो जाएगी,
हो जाएगी,
जांच में हो जाएगी।
जांच में ये बात साफ हो जाएगी।
यस।
उपरोक्त आरोप के जांच के क्रम में जो तथ्य प्राप्त हुए उनका विवरण ये है, तो वो इंक्वायरी के लिए उसी के बेसिस पे बोला गया था। हुजूर, ये इंक्वायरी रिपोर्ट है। नामकुम अंचल के ग्राम बरगावा के खाता नंबर 87 प्लॉट नंबर 4, 5 एवं 6 कुल रकबा 48 एकड़ जमीन का रिविजनल सर्वे खतियान में गैर मजूरा मालिक दर्ज है। इसी जमीन में से श्री हरिचरण साहू भूतपूर्व जमींदार द्वारा वर्ष 1948 में श्रीमती भगवती देवी के नाम 25 एकड़, दुर्गा प्रसाद अग्रवाल के नाम पर 16 एकड़ भूमि बंदोबस्ती कर दिया गया। वर्ष 1956 में श्रीमती भगवती देवी ने अपने 25 एकड़ भूमि में से कुल 2 एकड़ भूमि ठाकुर जगदीश नारायण सिंह को बिक्री कर दिया। कालांतर में श्रीमती भगवती देवी की मृत्यु के पश्चात उनके पुत्रों द्वारिका नंदन मोदी एवं देवकी नंदन मोदी ने वर्ष 1960 में निबंधित केवाला के द्वारा विपक्षी श्रीमती लक्ष्मी देवी, श्रीमती उर्मिला देवी, श्रीमती सुदामा देवी को कुल बचे 23 एकड़ भूमि बेच दिया। ये सभी तत्कालीन जमींदार हरिचरण साहू के पतोहू हैं। दुर्गा प्रसाद अग्रवाल ने वर्ष 1959 में निबंधित केवाले के द्वारा विपक्षी श्रीमती सिमालो देवी को समूचे 16 एकड़ भूमि को बेचा। ये तत्कालीन जमींदार हरिचरण की अपनी पत्नी है। जांच से पता चला कि चारों खरीदारों द्वारा पूर्ववर्ती तत्कालीन अंचल पदाधिकारी रामकुम के कार्यालय से दाखिल खारिज करा लिया एवं रसीद कटना प्रारंभ हो गया। वर्ष 1975-76 में तत्कालीन अंचलाधिकारी के द्वारा उक्त भूमि पर 4H की कार्रवाई प्रारंभ करते हुए रसीद निर्गत किया जाना बंद कर दिया गया। तब उनके द्वारा पूर्ववर्ती तत्कालीन अंचलाधिकारी नामकुम के समक्ष प्रस्तुत भूमि का लगान रसीद निर्गत करने हेतु आवेदन दिया गया। अंचलाधिकारी ने इस संबंध में दर्ज मिसलेनियस केस नंबर 5 से 8 7980 में दिनांक 21/4/1980 को आदेश फलक पर लिखा कि इस भूमि पर प्रारंभ से आज तक दखल नहीं रहने के कारण एवं सरकारी आदेशानुसार रसीद निर्गत करना स्थगित कर दिया गया। आवधिक भूमि नामकुम टाटा रोड से सटे होने के कारण सरकारी एवं जनहित के उपयोग में लाया जाता है। इसके अंतर्गत नामकुम बाजार, महावीर मंदिर एवं खेल मैदान है। यह भूमि सन 1943 से सैनिकों के अस्थायी अर्जन में था, जिसे भूतपूर्व जमींदार द्वारा 1948 में अपने निकट संबंधी के साथ बंदोबस्त किया गया है। इससे यह प्रतीत होता है कि यह अवैध बंदोबस्ती है। उपरोक्त टिप्पणी करते हुए अंचलाधिकारी ने रसीद निर्गत करने पर सरकार को क्षति होने की संभावना को देखते हुए भूमि सुधार अधिनियम की धारा 4H के अंतर्गत कार्रवाई हेतु अनुशंसा कर अभिलेखों को उपसमाहर्ता भूमि सुधार रांची को भेजा। इस अभिलेख के आधार पर तत्कालीन भूमि उपसमाहर्ता सदर रांची के कार्यालय में अभी संख्या 1 से 4/8081 में खोलकर धारा 4H के अंतर्गत कार्रवाई शुरू की गई। जांच के क्रम में अभिलेख संख्या 1 के अवलोकन से पता चलता है कि तत्कालीन उपसमाहर्ता भूमि सुधार सदर रांची ने विभिन्न बिंदुओं पर जांच कर जांच प्रतिवेदन समर्पित करने का निर्देश 12/9/90 को अंचलाधिकारी नामकुम को दिया। मतलब एट दैट टाइम पिटिशनर वाज पोस्टेड। तत्कालीन अंचलाधिकारी एज सर्किल ऑफिसर
सीओ
अंचल अधिकारी नामकुम को दिया, मतलब यू रिसीव्ड दैट,
मतलब दैट डायरेक्शन वाज गिवन टू द पिटिशनर। तत्कालीन अंचलाधिकारी नामकुम श्री दिनेश कुमार ने दिनांक 14/11/90 को अपना जांच प्रतिवेदन समर्पित किया, जिसमें उन्होंने गवाहों के सुने सुनाए बयान के आधार पर लिखा कि कागजातों के अवलोकन से पता चलता है कि 4H का कोई केस नहीं बनता है।
This is the only allegation against him.
Yes, मतलब this is the allegation, मतलब that has been recommended LRDC, मतलब
Read that.
मतलब thereafter मतलब अंचलाधिकारी नामकुम के जांच प्रतिवेदन के आधार पर श्री सुबोध कुमार गुप्ता उप समाहर्ता भूमि सुधार सदर रांची ने दिनांक 27/12/90 को
This is LRTC.
यस मतलब LRDC आदेश फलक पर 4H की कार्रवाई स्थगित करते हुए अनुशंसा श्री कुमार राणा अवधेश सिंह तत्कालीन अनुमंडल पदाधिकारी के समक्ष की, जिन्होंने दिनांक 27/2/91 को अनुशंसा पर सहमति व्यक्त करते हुए अभिलेख को यूके शरण तत्कालीन अपर समाहर्ता को सांकित किया, लेकिन अपर समाहर्ता 26/12/91 को आदेश पारित किया कि अंचलाधिकारी नामकुम भूमि सुधार उप समाहर्ता रांची एवं अनुमंडल पदाधिकारी रांची की अनुशंसा से मैं सहमत हूं कि इस मामले में 4H का केस नहीं बनता है। तो एडिशनल कलेक्टर तक सब उसको अप्रूव कर दिए 1990-91 में। Thereafter, my lord, subsequently, my lord, it appears, my lord, in the next paragraph, your lordship will find. जांच के अभिलेख से अवलोकन से पता चला कि तत्कालीन अपर समाहर्ता MP अजमेरा और उपायुक्त रांची।
One line has been left, your lordship. इस प्रकार अभिलेख में कार्रवाई समाप्त कर मूल अभियुक्त उपायुक्त रांची के पास नहीं भेजकर सीधे भूमि सुधार उप समाहर्ता रांची को वापस कर दिए। डीसी के पास गया नहीं।
डीसी के पास कहाँ जाएगा? वही
डीसी के पास जाने का तो कोई ओकेजन भी नहीं था हुजूर, जब वो फाइनल ऑर्डर पास कर दिए थे।
Who is the final authority to pass the order?
The additional collector. He was the collector under 4H, my lord. Then, my lord, in the year 1993, my lord, the matter has been reopened, my lord.
Read that. जांच के अभिलेख में अवलोकन से पता चलता है कि तत्कालीन अपर समाहर्ता CM अजमेरा
तथा उपायुक्त रांची राजीव कुमार के संयुक्त आदेश दिनांक 28/6/93 और 2/7/93 के अनुसार तत्कालीन अपर समाहर्ता यूके शरण द्वारा 26/12/91 को अभिलेख संख्या 1 में अंकित उपरोक्त आदेश के संबंध में यह टिप्पणी की गई कि बिहार भूमि सुधार अधिनियम की धारा 4H में अंतिम निर्णय लेने की शक्तियां मात्र राज्य सरकार को है तथा RS खतियान के अनुसार खाता नंबर 87 प्लॉट नंबर 48 एकड़ भूमि गैर मजरूआ है। इस प्रस्तुत भूमि सुधार अधिनियम की धारा 4H की कार्रवाई के लिए उपयुक्त है। तदनुसार आदेश में अंचल अधिकारी को 4H के अंतर्गत जमाबंदी रद्द करने की कार्रवाई करने का प्रस्ताव भेजने हेतु निर्देश दिया गया तथा इस आदेश की जानकारी अनुमंडल पदाधिकारी उप समाहर्ता रांची को दिया गया। मतलब this order has been challenged before the High Court, my lord, so far as that part is concerned, and that has been set aside, my lord. मतलब then, my lord, तत्कालीन उपायुक्त रांची श्री राजीव कुमार ने केस नंबर 26R9394 श्रीमती लक्ष्मी देवी में धारा 4H में दिनांक 17/11/93 को आदेश पारित के पृष्ठ संख्या 19 में उल्लिखित किया कि भूतपूर्व जमींदार ने वर्ष 1948 में भगवती देवी दुर्गा प्रसाद अग्रवाल को बंदोबस्ती किया। वह बेनामी था जिसे वर्ष 1960 में भूतपूर्व जमींदार ने उक्त विवादास्पद भूमि को अपनी पत्नी सिमालो देवी और पुतोहू लक्ष्मी देवी, सुदामा देवी, उर्मिला देवी के नाम से निबंधित पट्टा द्वारा करा लिया। उपायुक्त रांची के उक्त आदेश के पृष्ठ संख्या 20 में इस बात का उल्लेख है कि भूतपूर्व जमींदार को भूमि अधिग्रहण वाद संख्या 33/44/45 की जानकारी थी। इसी कारण विवादास्पद भूमि पर बेनामी बंदोबस्त वर्ष 1948 में करके बाद में वर्ष में अपने परिवार के नाम पर, जबकि वे लोग दखल कब्जा में नहीं थे, स्थानांतरण करवाकर दाखिल खारिज करवा लिया ताकि सरकार से अत्यधिक क्षतिपूर्ति प्राप्त कर सके। इससे पूर्व भूतपूर्व जमींदार के परिवार सफल हुए। चारों श्रीमती लक्ष्मी देवी, श्रीमती सुदामा देवी, श्रीमती उर्मिला देवी और सिमालो देवी ने प्रस्तुत भूमि जो राष्ट्रीय उच्च पद तथा सैनिकों के लिए भूमि सरकार द्वारा लिए जाने पर क्षतिपूर्ति हेतु आवेदन दिया। फलस्वरूप भूमि अधिग्रहण वाद संख्या 34/44/45 में भूतपूर्व जमींदार के पुतोहू सुदामा देवी ने 1.25 एकड़ भूमि के लिए कुल 5,627, उर्मिला देवी ने 6.35 एकड़ भूमि के लिए 22,774 को 22,668.15, 3,78 को 1,10,672 एवं वाद संख्या 19/64/65 और 22/65/66 में श्रीमती लक्ष्मी देवी ने 0.96 एकड़ भूमि के लिए तथा श्रीमती शिवालो देवी ने भूतपूर्व जमींदार की पत्नी ने 4.6 एकड़ भूमि के लिए क्षतिपूर्ति रकम प्राप्त किया। इस प्रकार भूतपूर्व जमींदार ने वर्ष 1948 में जो बंदोबस्ती किया था वह बिहार भूमि सुधार अधिनियम की धारा 4H के प्रावधानों को डिफीट करने के उद्देश्य से सरकार को क्षति पहुंचाने के उद्देश्य एवं अधिक मुआवजा प्राप्ति हेतु किया था। तत्कालीन उपायुक्त रांची ने अपने उपरोक्त आदेश के धारा 4H के अंतर्गत भूतपूर्व जमींदार के द्वारा की गई बंदोबस्ती को रद्द कर दिया है तथा इस आदेश की संपुष्टि सरकार ने पत्रांक नंबर 2197 से किया है। मतलब दिस हैज बीन अप्रूव्ड बाय द state government, my lord, as required under the section 4H, my lord, on 2/1/1997. My lord, this order has been challenged, my lord. I have filed the supplementary affidavit, my lord, so far as the order passed in the writ petition is concerned. My lord, kindly see the supplementary affidavit, my lord, for a moment, my lord. The order, my lord, that is reported in 2003, volume 2, JCR 469, my lord. This is the Lakshmi Devi and others, my lord. They have moved before this honorable court, my lord. Just, your lord, kindly see.
They had challenged the ground by which the deputy commissioner had ordered reopening of the 4H proceeding.
Yes, Lord.
Already closed pursuant to your initial recommendation.
Yes, Lord.
So the High Court has held that it cannot. Deputy commissioner doesn't have the power.
Yeah, Lord, that has been held to be illegal, my lord. So far as the 4H is concerned, that is not maintainable. My lord, that
single judge order. What happened thereafter? The single judge order.
That had went in appeal, my lord. The state went in appeal, my lord. The appeal dismissed for on the ground of delay. Thereupon, my lord, they went to the Supreme Court, my lord. I could not get the number, but my lord, I have been informed that the SLP has also been dismissed so far as the Supreme Court is concerned. Therefore, my lord, so far as the recommendation which is being said to be made by the petitioner with respect to the fact, my lord, that the no 4H proceeding.
Now, Madam Priyashish, tell me one thing. Allegation against this petitioner is that he had recommended, he has forwarded a recommendation with his own noting also, approving the noting sent by his subordinate that this case, no proceeding under 4H can be initiated. So that went up to the additional collector, it was upheld. So the matter was set at rest there, at the first instance. Now thereafter, again, another deputy commissioner and another official comes, they reopen it. Now that reopening has been set aside by the High Court. Now what remains? Now what remains? Once that reopening order has been set aside, the final order by which it was decided that the proceeding of 4H cannot be initiated, that survives?
Yes, sir.
Then?
On the recommendation made by this petitioner only.
So now thing is this, he had made a recommendation. Now you try to reopen it, the court says no, you cannot reopen. What is the criminal intent?
Lordship, further in the FIR, Your Lordship, 3 paragraphs only left, Your Lordship. सरकार द्वारा प्राप्त संपुष्टि के आधार पर अपर समाहर्ता रांची ने पत्रांक सच एंड सच 1997 अनुमंडल पदाधिकारी ने पत्र के द्वारा अंचल अधिकारी नामकुम ने अपने पत्रांक सच एंड सच बंदी 2 में कायम जमाबंदी रद्द कर दिया। अंचलाधिकारी नामकुम के कार्यालय से प्राप्त नामकुम अंचल के ग्राम बड़गावा खाता संख्या सच एंड सच खतियान को अभी प्रमाणित कर प्रति का अवलोकन करने से पता चलता है कि उपरोक्त भूमि खतियान में गैर मजबूआ मालिक अंकित है और ग्राम जमीन की प्रकृति प्रति कादिम मंझोला जंगल दर्शाई है। अंचल कार्यालय से नामकुम भूतपूर्व जमींदार हरिचरण साहू द्वारा दाखिल किए गए जमींदारी रिटर्न।
Limit yourself to this petitioner only. What is
yes, Your Lordship,
of this petitioner to attract an
इसमें इस लास्ट लाइन ऑफ द है कि 1948 में बंदोबस्ती का उल्लेख नहीं है। What was written earlier, Your Lordship, कि बंदोबस्ती 1948 में करा लिया था वो जमींदार हरिचरण साहू। इसमें यह उपरोक्त जांच से स्पष्ट है कि खाता संख्या सच एंड सच प्लॉट नंबर अवैध रूप से जमाबंदी खोलने में निम्नलिखित सरकारी कर्मचारी ने पदों का भ्रष्ट दुरुपयोग और सुनिश्चित षड्यंत्र के तहत किया गया है। Your Lordship, there is
They passed a wrong order. This is a quasi-judicial order. 4H and all these things.
yes, Your Lordship.
So, if you pass a wrong order, you will be proceeded against.
Wrong order with criminal intention, Your Lordship.
What is the criminal intention? Show me that. I'm asking you. In the entire affair, there is no criminal intention. What is the criminal intention? Show me. Tell me what is the criminal intention.
Illegal jamabandi was done, Your Lordship. To
See, first of all, 4H proceeding was not initiated. What will happen if a 4H proceeding is not initiated? Tell me.
Your Lordship, time may be granted to prepare myself, Your Lordship.
The land, as per you, land vested when?
1948, Your Lordship.
How can that be?
1948.
When is the legislation? What is the date of the legislation?
1956, perhaps, Your Lordship.
Yes, Mr.
This was 1950, my lord, the act was enacted, my lord.
Bihar Land Reforms?
Bihar Land Reform Act 1950, my lord.
Yes. Now 4H, the 4H can be initiated within a particular time.
Yes, my lord.
What is the time?
My lord, so far as the timing is concerned, my lord, there are two conditions which was required to be performed, my lord.
Yes.
Just I am seeing you. Bihar Land Reform Act. My lord, it says, my lord, just I am reading, my lord, section 4H is concerned. The collector shall have power to make inquiries in respect of any transfer, including settlement or lease of any land comprised in such state or tenure, or the transfer of any kind of interest in any building used primarily as office or kachari for the collection of rent of such state or tenure or part thereof. And if he is satisfied that such transfer was made at any time after the first day of January 1946, with the object of defeating any provision of this act or causing loss to the state or obtaining higher compensation thereunder, the collector may, after giving reasonable notice to the parties concerned to appear and to be heard, and annul such transfer, disposes the person claiming under it, and take possession of such property on such terms as may appear to the collector to be fair and equitable. Well, this was the provision, and once, my lord.
No, there is a period also. It cannot be
1946, Your Lordship.
No. Well, the period, my lord, it has been said, my lord, so far as the transfer is concerned, that should be after 1946 January.
It's after 46.
After 46.
After 46, because the act had come into force from 1950. So from 46, if there is any transfer,
January 1940.
The collector will inquire as to whether the same transfer was with the intention to
yes, well, to defeat the
provision of the act.
Bihar Land Reform Act.
Yes. Now 4H. Find out. Read that. 4H. Here. Land Reforms Act.
This is the Land Reforms Act. This aspect has been considered, my lord, in the judgment of the Honorable High Court, my lord.
Yes. What is the over here, when was the proceeding initiated? When it was sought to be initiated?
Pardon, Lord?
In this case, when was the proceeding sought to be
My lord,
initiated?
proceeding, my lord, the first was when
First one.
First one in the year 1990, my lord, the direction was given by LRDC to the petitioner to submit.
No, just tell me one thing. Just, can a proceeding under 4H be initiated after 50 or 60 years of the transfer?
My lord, so far as there is no limitation, my lord, but so far as the issue is concerned, my lord, the reasonable time must be there for initiation.
There are judgments you will get.
Yes, my lord, there are judgments, my lord, to that effect, my lord. And because, my lord, in the same matter itself, my lord, so far as
100 years also it can be initiated.
My lord, therefore, my lord, my submission is so far as the land in question is concerned, my lord, the proceeding under 4H which was initiated afresh, my lord, that has been set aside by the Honorable Court, my lord. Therefore, the question with respect to that part, my lord, that does not remain therein. And so far as the case of LRDC and SDO, my lord, Rana Udhay Singh and Subodh Gupta is concerned, even the landowner is concerned, Sudama Devi, their cases has already been closed, my lord.
Who is this petition? Who are the other petitioners in the other two cases?
My lord, the other cases, my lord, your lordship will see, my lord.
Same transaction.
Yes, my lord.
Who are
my
they?
lord, now they seeing, my lord, he was the SDO, my lord.
No, it's before me. The cases which are before this court.
My lord, the only one case, my lord.
No. Only one case. Only one case. Oh, sorry.
Yes, only one case, my lord.
The serial number?
47, my lord.
47. 47. Yes, what do you have to say? Anything more?
My lord, this my submission is, my lord, so far as the recommendation which is being said to be made by the petitioner with respect to the
Lord, Mrs. Shrestha, the only allegation of this petitioner that he has forwarded a recommendation with his note.
Yes, Your Lordship.
And that note was accepted by the higher authorities.
Yes, on the ground of his recommendation.
Yes, not only his, they have also applied their own mind, and it has now the government sought to open it. The High Court quashes the same.
One CRMP that was annexed, Your Lordship, Annexure 4 is Sudama Devi. Petitioner position is different from this petitioner, Your Lordship.
Sudama Devi was the
and The role of this Rana Avdesh Kumar is also different, Your Lordship.
Sudama Devi is
Role of this petitioner is different from Rana Avdesh.
Sudama Devi is a direct beneficiary.
Lordship.
Sudama Devi is a direct beneficiary.
Yes, Lordship.
So, when her case is quashed, Rana
Ran-
Rana SDO. He is the
SDO.
SDO.
His case has also been quashed.
This is also quashed. And this person is the
Circle officer.
Circle officer. He has made the inquiry and recommend the matter, Your Lordship.
First recommendation.
To the SDO or other person.
circle inspector most probably has made the report. First recommendation.
Circle officer, Your Lordship. Circle officer. Yes, Your Lordship.
So SDO accepted it. SDO accepted his recommendation.
Yes, Your Lordship.
So when SDO could have easily refused to accept, he could have deferred. When SDO accepts and SDO's case has been quashed, tell me why not this? Order is a
Lordship. Blindly.